So there is this enormous disconnect between why the few who spoke in favor of it said they needed it for personal privacy and what is actually in the bill, which has nothing to do with protecting individuals' personal privacy rights, and the existing statute, GRAMA, which has loads of provisions. In fact, there is one provision that I litigated for 3 years. It's called EnviroNews versus Salt Lake County. And we filed a lawsuit against Salt Lake County to get an independent investigative report that documented incidents of alleged sexual harassment by a high-ranking Salt Lake County official in the clerk's office that went on for a long period of time. And the complainant, who was a subordinate in his office, said that she was harassed over a long period of time, and higher-ups in the county ignored it, turned a blind eye, and this went on for a long time. We thought that there was public value in knowing the content of that report. The GRAMA statute exists for records like that to be revealed to the public. The complainant had already gone public. She was talking to the media. She had filed a federal lawsuit, so there was no privacy interest. The public official whose conduct was in question had already been publicly identified. And besides, you don't have a privacy interest in committing sexual harassment in the workplace. Woo! So we litigated that case for 3 years. We went through all the levels of appeal, took it all the way to the Utah Supreme Court, and this is the decision. It found that the record was public, that the trial judge was wrong when he denied access, our access to it. And it enshrined in the case law in the state of Utah this presumption of public access to the records, okay? And the legislative intent language that Cheryl Lynn was talking about that says when you have countervailing interests for and against release of a record, okay? It's a close call, and those interests balance, they fight to a draw. It's even. The tie goes in favor of public access, okay? That is in the legislative intent of GRAMA, and that is in this case. And the senators and the people who are supporting this bill have said they want to pass this bill to reverse this decision. Okay? They want to take this off the books, and they want to strip out that legislative intent language. That is critical language to the statute. That is non-negotiable. That language cannot come out of the statute. And you know, the speaker who would have the national perspective, it's interesting because I speak at the media bar is a small bar nationally. I speak to other media lawyers all the time. I go to conferences. We swap notes and compare whose statute is better, blah, blah, blah. When Utah passed GRAMA, we were definitely in the top, I would say, quartile of best sunshine laws in the state, maybe even, you know, the top fifth. It was very, very good statute. And then it's like the death of 1,000 cuts. You know, every session there's just nibbling away at that right of access. And even before HB 477, I'd say we were above average. We had a pretty good law. I mean, we had this ability to go to the State Records Committee, which is a group of citizens and media folks and government people. You can make your pitch and get access. Very few states have that. That is a real progressive feature of our law. And with the passage of this law, I've just been getting inundated with the media law colleagues around the nation. They are just flabbergasted at what has happened in Utah. I think everybody is. It is a sea change in the law, and so you know you've got the power. Hopefully, we've educated you some about the process, what happened. I mean, the cram down, the way this happened, and how unconscionable that was. The fact that the justifications that are being used for it are non-existent and have no basis in fact or in law. And the fact that they made a big miscalculation here. And I told this legislator, when he told me what was going to happen, I said, you have made a big miscalculation. I said, you think it's just about us, but wait until this comes out. I said, you guys are going to be in the hot seat. And the public outrage is going to be incredible with what you've done. And you have proven me right in that conversation. involved in the referendum process, that you support the legislators that are now coming out in favor of repealing the bill, and Senator Wimmer, is the senator? Representative Wimmer has called for a special session of the legislature to repeal the law. I think there will be others that follow. Craig Howe is backpedaling. So you need to support those efforts to repeal and also support the referendum, because unless that happens, they're just going to kick the can down the road. Thank you very much for your time.